Hey guys, my name is Ryan Nerney, and I am a managing partner at the nationally recognized security clearance, military, and federal employment law firm Tully Rinke. Welcome to the third episode of the podcast for the National Security Clearance Lawyers Association. This is the one and only podcast made to teach people from all industries that require a security clearance the ins and outs of the security clearance process, what adjudicative bodies look for, and potential disqualifying and mitigating conditions, and what potential and common situations mean for your security clearance. So whether you're an employee for a government contractor, a federal employee, or a member of the military, we're hopeful that you'll be able to pick up a few things of useful information when you listen to the NSLA podcast. So today, for our third episode, we're going to start a new series where we talk about the specific adjudicative guidelines for the security clearance process. Beginning with the rare guideline that we don't usually see, which is Guideline A for allegiance to the United States. By the end of this episode, we'll hopefully be able to give you a general understanding regarding what adjudicators look for regarding Guideline A cases and the disqualifying and mitigating conditions for this unique guideline. So let's jump right into it. If you tuned in for any of our other episodes, you learned that any adjudicator for security clearances focuses on review of the 13 adjudicative guidelines disclosed in the Security Executive Agent Directive 4 pursuant to the Executive Order 12968. So this consists of, as you know, guidelines A through M. Today we're going to talk about Guideline A, which again is the allegiance to the United States. So Guideline A is a unique and rarely used adjudicative guideline that typically involves behavior that calls into question a person's allegiance and loyalty to the United States. The adjudicative guidelines readily admit that there's no positive test for allegiance to the United States, but instead they look for participation or support for acts against the United States or placing the welfare of the interests of another country above those of the United States. This can also involve individuals who engage in acts against the United States or even provide support or encouragement to those who do and have demonstrated a willingness to compromise national security. One of the topics that is currently relevant that likely falls under this guideline is participation or even association in the January 6th insurrection. Obviously, that's a big topic of discussion, on Capitol Hill, and that is something that would fit neatly into the Guideline A allegations. The disqualifying conditions that typically elicit a Guideline A allegation are involvement in, support of, or even advocacy of any act of sabotage, espionage, treason, terrorism, or sedition against the United States. Association or sympathy with persons attempting to or committing any of those acts, and association or sympathy with persons or organizations who are advocating or threatening or using force or violence in an effort to overthrow or influence the U.S., federal, state, or local governments also are disqualifying conditions. Additionally, any individuals who prevent officials from doing or performing their official duties or preventing others from exercising their rights under the Constitution of the United States. Any of those aspects are Guideline A concerns, and you can kind of see based upon my explanation of the disqualifying conditions that the January 6th insurrection kind of fits neatly into some of those things. So while Guideline A is a unique guideline that we don't see too often, the January 6th, attack on the Capitol or insurrection, as people call it, is a prime example of what would elicit a Guideline A concern. Any person that would be involved in this type of behavior would find it very difficult, if not impossible, to obtain a security clearance with any government agency or government contractor. Again, that just goes directly to, supporting your involvement in, trying to overthrow the U.S. government. That's obviously a major national security concern, and that would readily impact anybody's ability to obtain or maintain a security clearance. The January 6th insurrection goes directly to disqualifying conditions A and C of the SEED 4 that I discussed earlier that has the 13 adjudicative guidelines. As the aim of the group and or groups responsible for that specific incident, and even some individuals that have already been found guilty by a court engaging in that type of behavior, did engage in the use of force to attempt to overthrow or influence the government, and also even prevented congressmen from doing their jobs because they couldn't do it, obviously, because they didn't have access to their offices. So specific acts like that go directly to the Guideline A allegations. Other concerns that we typically see, prior to obviously January 6th, or even, today, are association or involvement with extremist or terrorist groups that also meet the criteria for the disqualifying conditions I was just going over. Involvement in like white supremacist groups, terrorist organizations, either domestically or abroad, and even organized criminal organizations. Those are some other aspects that we see. While they ask that a list of the Guideline A allegations are typically serious, and this is obviously one of the most difficult guidelines to overcome, just given the nature of what the allegation and the guideline is, there are several mitigating conditions that could resolve a security clearance decision under this guideline in a person's favor. This includes an individual being unaware of the unlawful aims of the individuals or organizations. It has to be genuine. It can't just be, well, I didn't know, sorry. It has to be something that is genuine, that somebody really did not know what that organization or individual was all about. Also, involvement in any type of this behavior or these groups was a humanitarian situation or was even permitted under the U.S. laws. The involvement was only for a short period of time and was attributable to curiosity or academic interest. They were involved in this type of behavior or just association with this group for research purposes. Or one of the other ones that's kind of a catch-all mitigating condition is there were unique circumstances that occurred that caused the association with these types of activities. And there's no evidence that behavior will occur again in the future. So all these aspects are mitigating in nature and can be used, if true and accurate, to mitigate the Guideline A allegations. Specifically for me, talking about, a case that I've actually been involved in, and assisted some individuals with, I recall a case where an individual was attempting to get a security clearance with the Department of Defense, and they were issued a statement of reasons alleging concerns under this specific guideline, Guideline A, for association with an extremist group via social media, as well as posting on social media about some of those ideals and reading and posting about for example, the anarchist cookbook or other extremist literature like that. However, in this situation, the association of that individual was mainly for academic purposes and curiosity purposes, because they were performing research and trying to get as much information as possible for assistance with a dissertation for a master's or PhD program. So ultimately, in this specific situation that I'm aware of, we were able to mitigate the Guideline A concerns, and they were eventually granted a security clearance. This is just one example of a successful case, but as I'm sure, if you've been listening to this podcast, you should all be aware that each case is different, and it does depend on the individual facts and circumstances of each case regarding the type of outcome. As I mentioned before, and I mentioned throughout this episode, Guideline A is a very unique guideline that we don't see very often. As the adjudicators don't typically use this, they typically defer to what we call the catch-all guideline, or Guideline E, which is personal conduct. That guideline, which we'll talk about in later episodes, typically goes to, like I said, a more catch-all or a larger umbrella of conduct that adjudicators can utilize. However, on a few occasions, the adjudicators will utilize Guideline A if the behavior and the concerns not only fit that criteria, but also, are a major concern there. Anything in association with terrorist groups or things of that nature definitely would elicit something like the Guideline A allegations. And then could obviously impact anybody's ability to obtain and maintain a security clearance with any behavior associated with the disqualifying conditions that I went through earlier. So there you have it for this month's NSLA podcast episode. Please keep a lookout for more content to assist with your current and future security clearance journeys. Thank you for listening, and we look forward to you tuning into our next episode.